Welcome to our deep dive into the significant amendments made to the Industrial Disputes Act, 1947. Over the years, these changes have shaped the landscape of labor relations in India. Now, you might be thinking, labor laws? That sounds drier than a mouthful of unbuttered toast. And you wouldn't be entirely wrong. But stick with us, because these laws impact millions of workers and businesses across India. And frankly, understanding them is crucial. It's like trying to navigate the Indian rail system without knowing the timetable, messy, confusing, and likely to leave you stranded in a metaphorical station with nothing but a lukewarm chai and a growing sense of despair. Our story begins in 1953, just 6 years after India gained independence. The nation was still finding its feet, and the Industrial Disputes Act, 1947, was like a first draft, well-intentioned, but in need of some serious editing. The 1953 amendment swooped in with its red pen, adding crucial provisions for layoffs, retrenchment, and closures. For the first time, the Act defined the conditions under which these actions could be taken, and crucially, what compensation workers were entitled to. This amendment was a major step towards protecting workers' rights and ensuring fairness in the face of economic change. Fast forward to 1964, and India's industrial scene was buzzing. But as the economy grew, so did the potential for exploitation. This is where the 1964 amendment steps in like the strong, silent type in a Bollywood movie, all clenched fists and meaningful glances. This amendment introduced the concept of unfair labor practices, essentially handing workers a shield against intimidation, discrimination, and other shady dealings. By 1971, India had weathered wars and famines, but industrial disputes were still throwing a spanner in the works. The 1971 amendment swooped in with a focus on peace and harmony, like a well-meaning uncle trying to mediate a family argument. This amendment beefed up the provisions for conciliation and settlement, encouraging parties to find common ground instead of duking it out in court. It was all about fostering a more collaborative approach to industrial relations. Chapter 4. The 1976 amendment was all about streamlining the system. It brought in the concept of appropriate government, clearly defining which government body had jurisdiction over specific industries. Think of it as assigning traffic cops to busy intersections. It ensured smoother flow and fewer disputes about who was in charge. Chapter 5. Hold on to your hats, folks, because the 1982 amendment was a game changer. Especially for larger establishments, it introduced Chapter VB, which brought in stricter regulations for layoffs and retrenchments in companies with 100 or more workers. The amendment also tightened the definitions of industrial establishment and continuous service, leaving less room for employers to exploit loopholes. Chapter 6. The 1984 amendment built upon the 1982 changes, making it crystal clear that compensation during layoffs and retrenchments wasn't some optional bonus, but a legal requirement for establishments with over 100 employees. It was a major win for workers' rights, ensuring that losing their job wouldn't automatically throw their lives into financial turmoil. Chapter 7. By 1996, India was on the cusp of a technological revolution, but the wheels of justice for industrial disputes were still turning at a snail's pace. The 1996 amendment aimed to change that, streamlining procedures to expedite dispute resolution. It also upped the compensation for retrenchment and other benefits, acknowledging the rising cost of living and ensuring workers were adequately provided for. The 2010 amendment continued the trend of strengthening workers' rights. It raised the wage ceiling for retrenchment benefits, meaning more employees were eligible for compensation. It also introduced a provision for voluntary arbitration, allowing employers and employees to opt for a more collaborative dispute resolution mechanism. The 2016 amendment took a two-pronged approach, simplifying the process for filing and addressing disputes while also strengthening penalties for unfair labor practices. It was all about making the system more accessible and efficient while sending a clear message that exploiting workers wouldn't be tolerated. And finally, we arrive at the big one, the Industrial Relations Code 2020. This wasn't just an amendment, but a complete overhaul of the system, merging several labor laws, including the Industrial Disputes Act. This new code introduced significant changes like raising the threshold for government approval for layoffs, retrenchments and closures. A move that sparked debate about striking the right balance between worker protection and business flexibility. These amendments and reforms reflect India's evolving approach to managing industrial relations, balancing workers' rights with industrial growth. From those early days in 1953 to the sweeping changes of the Industrial Relations Code, the journey of the Industrial Disputes Act is a testament to India's commitment to creating a fair and equitable workplace. But the story doesn't end there. As India's economy continues to evolve, so too will its labor laws, requiring ongoing dialogue and adaptation to meet the needs of both workers and businesses.